Hey there, it's me, Alex William Smith, better known to many of you as Jonathan Royal, hypnotist and magician of magicalguru.com. I've got some news regarding my fake Sheikh Mazher Mahmood related convictions on my quest to clear my name and get those convictions overturned, as per the information on circusofthemind.net. But first, here's some good news. The reason I say first here's some good news is because, as you can see on screen, on September the 30th, 2022, case number as shown was submitted. This is my civil litigation case regarding privacy intrusion and such. Now, the reason that's good news will become clear later because there'll be a disclosure process along the way, and then hopefully I can get hold of certain documents that I believe exist, which will give me the ability then to reapply to the Criminal Cases Review Commission with new, fresh, strong evidence of the unlawful information gathering techniques and other activities of So it's arrived 5 months and 11 days after it was submitted in May 2022. My latest application to the Criminal Cases Review Commission. The reason I say latest is because there will be more, as we'll cover very, very shortly. But it's come and it's dated 31st of October 2022. And yeah, they made a decision on my latest CCRC application to have my Mazher Mahmood fake Sheikh News of the World, Rupert Murdoch's news group newspapers publication related convictions from the 1998 article looked at, and this document, this PDF, will be on circusofthemind.net along with all the other relevant documents to be downloaded. There's 6 pages of it, and the bottom line is, I mean, they get some of the dates wrong as well. For example, I never pled guilty on the 1st of February 99. Everything was, as explained at circusofthemind.net, on the 1st of March 1999. But hey-oh, aside from the fact there's various errors in here, they lay out basically pretty much the same as the judges said at the Court of Appeal in January 2022, which is that ultimately, in a nutshell, the summed up version is that because I knew who Mazher Mahmood was, because my intention was to expose the unethical and dishonest techniques he was using, that they don't feel that his dishonesty, unlawful and illegal actions have got any relevance. The main issue, which is what the Court of Appeal said is, and I'll quote this bit, is the Court of Appeal in January 2022 observed at paragraph 20 of the judgment, which is on circusofthemind.net, that it had always been your case and at an early stage of appeal that it was you who had set out to entrap Mr. Mahmood, not the other way around. The Court of Appeal observed that your assertion that you were, in 2022, the victim of entrapment, in some way pressured, induced or threatened to produce the counterfeit coins was at total odds with this case. The Court of Appeal further observed that there simply are no particulars of any of the alleged pressure, inducement or threat as suggested by you, whilst is noted in your comments that you still maintain that you set out to expose Mr. Mahmood, but that you also felt pressured. The argument you have raised in relation to Mr. Mahmood is not a new argument. As is fully detailed and outlined at circusofthemind.net, where you can see my perfected grounds of appeal and other documents and videos, all of which the CCRC's attention were drawn to, and they said they would look at. If they had looked at them, surely they would have seen that the reason why things like me being pressurised behind the scenes, both by Mahmood staff and also my former publicist, who was involved, as explained again at circusofthemind.net, the reason there's nothing to show that happening is because it was done behind the scenes. This is the stuff that was done off tape or edited out of tapes, as is Mahmood's long-term modus operandi. Pressure was on behind the scenes. Madness. Another bit I'll draw your attention to is they say in your third ground you have stated there is fresh evidence from Royal Mint that calls into question the basis for the prosecution. The Court of Appeal observed that Royal Mint simply says that it had no record any longer of any examination of the coins. This is in the context of the Court of Appeal's reflection on the substantial prejudice on the prosecution due to the long delay in appeal since the evidence in the case is no longer available. Well, that's not entirely the case, is it? Because if you go to circusofthemind.net and click onto the page where there's my 24 years of research into Mahmood's activities, you'll see a copy of an email from the Royal Mint that I got when I did a Freedom of Information request, where they say they keep records from 1998, 99 and all that time period. They do keep records from that time period. So therefore, that implies that they should have records if any coins were sent in relation to the News of the World article and case against me. However, they go on to go and say that they checked against all my different stage names, my birth name, against the News of the World, the CPS, and all other possible connotations, and they could find no coins sent at the relevant time period for the article and or my subsequent court case in 1999. Now, when the Crown Prosecution Service contacted them and asked if my email that I'd submitted as evidence was genuine, they clarified that it was genuine and what they'd said to me was true, but then they added a sentence saying, whilst we keep stuff from that time period, it's not entirely impossible, words along the lines of not entirely impossible that we may have lost or misplaced something. However, this still means that in the general course of things, they keep records from that time period. We have to assume the Royal Mint, being such as it is, would not, it's not a routine thing for them to lose stuff. At no point have they categorically said they've lost anything. In fact, what they seem to make clear in the original email to me is they keep stuff from that time period, but they have nothing connected to my name. I would suggest that nothing was ever sent to them, given the other glaring errors that have been made along the way in this case. I think the biggest substantial paragraph from the Criminal Cases Review Commission's refusal letter of the 31st of October 2022 is this. In your application, you have raised that you have new evidence and supporting statements. Well, I do run into over 2,000 pages of stuff from numerous different people. The Court of Appeal addressed the nature of the evidence that ranges from matters relating to the trial of the singer Talisa Kontos Tavlos, the Leveson inquiry, the telephone hacking litigation involving the News of the World, and the Beckham kidnap trial, paragraph 15 of judgment. This fresh evidence is linked to the wider conduct of Mr. Mahmood as a journalist, and the full court explained that the key issue in relation to the offence, meaning my offence, was whether you knew you were handing over counterfeit coins, irrespective of dishonesty on the part of Mr. Mahmood, paragraph 24, Court of Appeal judgment. The Court of Appeal did not grant leave to appeal, taking into account the exceptional extent of the delay in question and the lack of any properly particularised explanation for it. The CCRC has not identified anything within your application and the material provided in support which represents new evidence, information or legal argument that could have advance on any of the matters. What? Well, firstly, it's laughable that apparently Mahmood's dishonesty, they think's irrelevant to it, and they say it's all a case of whether I knew the coins were fake or not. Well, here's the thing. I never forensically tested the coins, and there's a suggestion there that they never did either. And all the evidence now seems to illustrate, as has been the modus operandi in many other Mazher Mahmood events, that I was supplied the information of where to obtain them from one of Mahmood's staff behind the scenes. I was supplied the money in advance by Mahmood, and ultimately, therefore, he was responsible for all areas of the supply chain. It would appear he incited the crime, he supplied the money for it to be fulfilled, and he supplied the information through his associates of where to obtain it. This is pretty much identical to what happened in the Model M Morgan's case, where Mahmood's former photographer and driver, Steve Grayson, categorically said on BBC Panorama that they ultimately supplied the drugs and the information where to get it and the money in advance. Same thing happened, but with alleged counterfeit pound coins in my case. I say alleged because they don't appear to have ever been checked. And here's the other thing. There was no chain of evidence anyway from when they were handed over to Mahmood on a Friday until nearly 2 weeks later when he finally gave them to the police. And we know with Mahmood's dishonesty that he cannot be trusted. Indeed, based on the documents and my perfected grounds of appeal and stuff alluded to in there, the police and Crown Prosecution Service both knew Mahmood could not and should not be trusted as a witness of truth as far back as 1994, and that subsequently from 1994, numerous other people brought into question Mahmood's dishonesty and arguably illegal actions, and cases collapsed along the way as well. And none of this was ever disclosed to me or other Mahmood victims via the Crown Prosecution Service or the police. Why not? Had it been known about at the time of trial, then my representation would have been able to get a stay in proceedings and no trial would have gone ahead, no court case would have gone ahead. The same is in relation to Mahmood's use of unlawful information gathering, things like phone hacking, which, as is mentioned in my perfected grounds of appeal on circusofthemind.net, I have seen evidence, i.e. receipts, that payments were made for unlawful information gathering, which means that Mahmood and his team were always one step ahead of me. In other words, when I thought I was trying to expose their techniques, they knew I was trying to do that and was doing that. They were always a step ahead of me, hence they were putting the pressure on behind the scenes and manipulating things to make me look as bad as possible. So why exactly is Mahmood's dishonesty not relevant? I think it's very, very relevant, as further illustrated at circusofthemind.net. And another thing, there's been errors galore along the way that are illustrated by the videos on circusofthemind.net, with paperwork, with wrong dates, wrong bits of information on and such like. Why did that ever happen? And also the suggestion that I was probably drugged, as many of Mahmood's victims over the years have also suggested happened to them, including to Lisa and her friends. They believe that their drinks have been tampered with, spiked at the very least. But my investigations seem to indicate that I was likely drugged with a GHB-style date rape drug. And indeed, I have a witness statement from Steve Grayson, who used to work with Mahmood, saying he'd witnessed Mahmood do that in the course of a sting. Another section in the CCRC's rejection letter of 31st of October 2022 says, in relation to available defences, as noted in the respondent's notice to your appeal dated 6th November 2015, it has not been suggested by you that seeking to expose the methods of a tabloid journalist could amount to a lawful authority or excuse. Pardon me? Well, it may not have been mentioned in 2015 in the documents that were submitted on my behalf by Siobhan Egan of Lewis Nadis Law when they were handling my appeal. However, it most certainly was raised back in 1999, and the only reason I changed my plea from not guilty to guilty on the 1st of March 1999 was after receiving what I now know to be bad advice. And the only reason it's bad advice is because I've now learned that the defence of entrapment and manipulation and all the other stuff that had gone on behind the scenes has worked for other people in the past. And also the fact is that Mahmood was afforded journalistic licence, or you may say lawful excuse, for purchasing alleged counterfeit coins, because his legal defence would be that his lawful excuse would be that he was purchasing them in the course of putting together a public interest news story. Well, as he never got charged for purchasing said coins from me, coins which incidentally were obtained from a place that one of his team had told me where to get them, and they'd supplied the money up front, so they were all parts of the supply chain, as his modus operandi was in many cases. But the fact is, I wasn't afforded the journalistic licence to pick them up, collect them, which is ultimately all I did, despite the fact, as the Magistrate Evening News articles show on circusofthemind.net, the judge and other parties accepted the evidence that I had at the time and provided that showed that my full intention was to expose the dishonest, unlawful and we now know illegal techniques of Mazher Mahmood and his team in creating fabricated stories. Now, on the one hand, they accepted the fact that I knew who he was, and they accepted the fact that my intention was to get a story on Mahmood to be published by, a rival paper, which I would have sold it to, had things not backfired slightly. And that backfiring obviously was more likely to occur as it did, because it turns out Mahmood and his team were always one step ahead of me because of the unlawful information gathering techniques they were using, and also the fact that my former publicist was supplying them stuff and on their payroll and helping manipulate things behind the scenes. So it very firmly was brought up at the time of trial, and has been brought up since. You can see my perfected grounds of appeal, or rather my draft of them from 2019, which is on circusofthemind.net. The issue of the fact Mahmood was afforded journalistic licence, so why wasn't I, is indeed brought up. Then the CCRC go to this chestnut that they're referring to the Court of Appeals in January, saying, but in any event, this demonstrates the total artificiality of the position now being presented before us. The applicant's own case was that he purchased the coins for £400. If true, that indicates that the coins must have been counterfeit. It is entirely consistent with his guilty pleas accepting knowledge of the fact that the coins were counterfeit. Oh dear. No, it doesn't. Firstly, Mahmood had the coins in his possession for 10 days from me having collected them from the source that his team told me where to get them from, and that Mahmood, supplied the money up front. So I effectively just collected coins from a place that they supplied the info of and supplied the money for. Secondly, as I refer you back to the information about the Royal Mint, who do keep records from that time period, but have nothing saying that the coins were ever checked. And thirdly, it was 10 days as mentioned on circusofthemind.net in the documents there, before Mahmood ever handed over the alleged coins to the police. Now, I say alleged in two manners. A, we have no proof that they were counterfeit because I don't believe they were ever checked, and the Royal Mint communication seemed to back that up. And secondly, there's no chain of evidence, no proof of what Mahmood did with those coins for 10 days. They may not have even been the same coins I picked up and took to him that he ultimately gave to the police. We do not know. There's no chain of evidence. Had we known about that at the time and Mahmood's dishonesty and stuff that's come to light since, then that alone would probably have been enough to get a stay in proceedings. But add to that the fact that there's evidence that unlawful information gathering was used, that could have got a stay in proceedings. Add to that the fact that there's now evidence that in 1994 the police and the Crown Prosecution Service both knew Mahmood should not and could not be trusted, but never disclosed that to me or other Mahmood victims. And if we'd known about that at the time, then that as well could have probably caused a stay in proceedings. The witness statement from Steve Grayson saying he witnessed Mahmood drugging somebody in the course of a sting, and all the people over the years, including Talisa Kontos-Stavlos, who said that they felt that their drinks were spiked. Well, it appears it may have been a date rape style drug. Surely all of these things are relevant, whatever my intention was. The fact that I knew who Mahmood was is frankly irrelevant, because the unlawful information gathering shows that he knew what I was up to in advance, and thus he used methods and coercion behind the scenes to make sure that I was entrapped and was a victim, including also having my former publicist on the payroll. It's all described in the documents at circusofthemind.net. Documents that the CCRC were meant to study and observe, but I honestly don't think they have. They've just cherry-picked things that were mentioned by the Court of Appeal in January, who again I don't think looked at things in depth, because they basically already decided they weren't going to give me an extension of time. However, it's not all completely bad news. Do not worry, because as this shows on screen on caseboard.io, on the 30th of September, this case number was filed, and it is my civil case against News Group newspapers for privacy intrusion on unlawful information gathering. And as part of that, there will be disclosure processes along the way. So I'm then hopeful that I'll be able to get hold of the contents of various files that News Group newspapers have already confirmed they hold on me, but have refused to give me under General Data Protection Registrar, GDPR, Freedom of Information requests. Several times I've requested them and they've refused, saying it was on the grounds of journalism, because they were intending to use what they hold in the course of journalism. Well, if that was the case, if they were intended to use such stuff in the course of journalism, why in 1999, after the conviction in the court over the News of the World article, did they never publish a follow-up like they normally do on other people? They never did a follow-up on me. Is it because the judge and people in court acknowledged the fact I knew who Mahmood was and my intention was to expose his dishonest techniques? Is that also why in the year 2000, as illustrated by the link above or below this video and the sources and stuff on circusofthemind.net, that when they ran an article in the Sunday Times and the News of the World, both Rupert Murdoch owned newspapers, about my, at the time, ebook autobiography, detailing my time as Britain's biggest ever media prankster, that they never mentioned their 1999 News of the World expose against me, and they never mentioned their 98 expose and their 1999 conviction secured as a result of their story. They normally bragged about such things, but they never did with me. Is it because in court, again, it was accepted that my intention was to expose Mahmood's dishonest techniques, and had they drawn more attention to it, it might have caused more of an investigation by other people at the time, and his activities could have got exposed on a much bigger scale much sooner than they did. Sadly, it took until 2014 and the collapse of the Tilisa Kontostavlos trial for his dishonesty to come to major light and for BBC Panorama to do an expose that his modus operandi was over the years the same with his victims, including me, as explained at circusofthemind.net. But all of that, you know, doesn't appear to have been taken into account. It seems to be that they think that just because I knew who he was, and I've always maintained that position ever since I walked into the police station in 1998 to give myself up and be interviewed, which I knew I'd have to be. I've always maintained that I knew who he was, and it was my intention to expose his tactics. However, the evidence shows that unlawful information gathering techniques were used. The evidence shows payments were made to my former publicist. People behind the scenes were manipulating things, and they knew what my intention was. I didn't know they knew. So they were always one step ahead of me. So I was entrapped, I was manipulated, and there's all the other questions like no chain of evidence on the coins. What happened to them for the 10 days from me picking them up from where I was told by one of Mahmood's teams, using money that they supplied and then delivering them to him? Where were those coins for the next 10 days before they were allegedly handed to the police? The coins were never checked, I would argue. Again, I refer you to all the documents at circusofthemind.net. And I've got a statement from Steve Grayson saying he witnessed Mahmood drug somebody in the course of a sting, which further clarifies the thing that I'm pretty certain I was as well, which explains why I felt so hungover the following day despite not having drunk as much as I usually did. And that made me more suggestible, not thinking as clearly, because I never had any intention of doing anything illegal. But in any event, I've also always argued the point that I should have been afforded the same journalistic licence. Mahmood never got charged for buying coins or inciting me to go and collect them, however you want to look at it. And yet I was for going and collecting them from a source that he told me, well, his team told me where to get them, and they supplied the money up front. And the CPS knew as far back as 1994 that he should not and could not be trusted. The whole thing stings. We need Leveson Inquiry Part 2 more than ever, because one of the things that we're going to look into was Mazher Mahmood and his activities and corruption and links with the police and CPS. It needs to happen. Thank you. Look at circusofthemind.net for documents that back all this up.